faith. Yugoslavia then brought charges to the World Court, invoking the Genocide Convention. The U.S. government excused itself on grounds of its self-exclusion from charges of genocide. The court, keeping to its statutes, accepted this argument. There are other examples of self-exemption from core principles of international law, also of crucial contemporary relevance. One arose in the case brought to the World Court by Nicaragua against the United States. Part of Nicaragua's case, presented by Harvard University law professor and former legal advisor to the State Department, Abram Chayes, was rejected by the court on the grounds that in accepting World Court jurisdiction in 1946, the United States had entered a reservation excluding itself from prosecution under multilateral treaties, including the UN Charter and the OAS Charter. The court therefore restricted its deliberations to customary international law and a bilateral U.S.-Nicaragua treaty. Even on these very narrow grounds, the court charged Washington with unlawful use of force, in lay language, international terrorism, and ordered it to terminate the crimes and pay substantial reparations, which would go far beyond paying off the huge debt that is strangling Nicaragua. We return to the bitter aftermath. The relevant point here is that the court correctly recognized that the United States is self-exempted from the fundamental principles of world order, that it played the primary role in formulating and enacting. It would seem to follow that Washington is entitled to commit aggression as well as genocide. Aggression, in the wording of the Nuremberg Tribunal, is the supreme international crime, differing only from other war crimes, in that it contains within itself the accumulated evil of the whole. All the evil in the tortured land of Iraq that flowed from the U.S. and U.K. invasion, for example. That includes Abu Ghraib, Fallujah, and everything else that happened in the truly horrible and brutal years for hapless Iraq since the invasion. And if, as seems reasonable, we take the accumulated evil to include effects outside Iraq itself, the accounting is still more grim, leading right to the inescapable question. The concept of aggression was defined clearly enough by Justice Robert Jackson, Chief of Counsel for the United States at Nuremberg, and was restated in an authoritative General Assembly resolution. An aggressor, Jackson proposed to the tribunal in his opening statement, is a state that is the first to commit such actions as invasion of its armed forces, with or without a declaration of war, of the territory of another state, or provision of support to armed bands formed in the territory of another state, or refusal notwithstanding the request of the invaded state to take in its own territory all the measures in its power to deprive those bands of all assistance or protection. The second provision clearly applies to the U.S. war against Nicaragua, though giving the Reaganites the benefit of the doubt, one might consider them to be guilty only of the lesser crime of international terrorism on a scale without precedent. The first applies to the U.S. and U.K. invasion of Iraq, unless we avail ourselves of the more imaginative devices of defense attorneys. For example, the proposal by one respected legal scholar that the United States and U.K. were acting in accord with the UN Charter under a communitarian interpretation of its provisions. They were carrying out the will of the international community in a mission implicitly delegated to them, because they alone had the power to carry it out. It is irrelevant that the international community vociferously objected, even more strongly if people are included within the international community. Also irrelevant are Justice Jackson's eloquent words at Nuremberg on the principle of universality. If certain acts of violation of treaties are crimes, they are crimes whether the United States does them or whether Germany does them, and we are not prepared to lay down a rule of criminal conduct against others which we would not be willing to have invoked against us. and elsewhere. We must never forget that the record on which we judge these defendants is the record on which history will judge us tomorrow. To pass these defendants a poisoned chalice is to put it to our own lips as well. Telford Taylor, Jackson's chief counsel for war crimes, writes that those were beautiful words, but did the results match the aspiration? Hardly, which I take it was Taylor's point. In the early phases of preparation for the tribunal, Taylor had already voiced his skepticism with regard to the core principle of Nuremberg, the crime of launching aggressive war. This phase of the case, Taylor wrote, is based on the assumption that it is or will be declared a punishable offense to plan and launch and lose an aggressive war. It was indeed so declared at Nuremberg, but the principle of universality was quickly rescinded, and Taylor's concerns proved all too valid. The official explanation for Washington's self-exemption from the rule of law in the Nicaragua case, presented by State Department legal advisor Abram Sofar, might also have received a nod of approval from Carl Schmitt. The World Court was disqualified for the same reasons as was the ICRC. It disagreed with Washington. Accordingly, it was a hostile forum, as the New York Times editors concluded, in approving Washington's rejection of court orders, which has left the United States in splendid isolation in defiance of World Court rulings, no longer in the exalted company of Muammar Gaddafi and Enver Hoxha, now that Libya and Albania have complied with the final judgments. The bias of the World Court, in fact, extends to the world generally, Sofar explained. The world majority often opposes the United States on important international questions, so that we must reserve to ourselves the power to determine which matters fall essentially within the domestic jurisdiction of the United States, as determined by the United States. In this case, international terrorism that practically destroyed the targeted country. The basic principles taught to the world by Sofar were spelled out to Mexicans by Condoleezza Rice when she visited in March 2005 to ensure that they would live up to their obligations under a 1944 treaty to deliver water to the United States. That compliance was the only formal outcome of the 7-hour visit, the Mexican press reported, though Rice did comment on another matter of interest to Mexicans: Washington's abrupt withdrawal from the Vienna Convention on Consular Relations, after the World Court ruled against the United States in the cases of 51 Mexicans who had been sentenced to death after the United States had violated their right to consult with officials from a Mexican consulate. We will continue to believe in the importance of consular notification, Rice explained, but international court jurisdiction has proven inappropriate for the United States. In short, the Mexican press concluded, Rice was telling the Mexicans that while they had a water treaty to live up to, the United States could simply withdraw from a signed agreement that it found inappropriate. Confirming the enforceability of those different options was surely one of the things Rice's visit was all about. More generally, it is what international law is all about, when those with the power to set the rules are permitted to do so by their own citizens. Neither Nicaraguans, nor Mexicans, nor many others need the instructions provided to them once again. A long history suffices. The Vienna Convention was proposed by the United States in 1963 and ratified in 1969. The United States was the first country to invoke it before the World Court, successfully in its suit against Iran after the 1979 hostage-taking. International law and court judgments are fine, but only when they come out the right way. Anything else is inappropriate for the United States. The basic problem with the World Court and the world, so we learn from UN Ambassador John Bolton, is that they misinterpret international law. One of the administration's legal specialists, Bolton, writes,